Indictable-only offences are of most serious nature in UK, and these include murder, rape, robbery, wounding, and cases like this. These could only be dealt in the Crown Court. Moreover, the magistrate court, when a case starts, it shall be sent in the magistrate court, but the plea shall be taken in the Crown Court. The plea that either a person saying that he pleads guilty or not guilty. While the defendant will have the first hearing in the magistrate court, it shall only be an administrative hearing to start the court process. The magistrate court is incapable of taking plea. The plea will be entered in the Crown Court. And if trial is necessary, it can only occur in the Crown Court for indictable offences. And if the defendant needs to be sentenced for an indictable offence matter, it can only take place in the Crown Court. But there are cases in which a person might be charged with an indictable only offence as well as a summary offence. For example, he might be charged with robbing a person and committing a common assault on that person's friend to get away, which is a summary offence. Robbing a person is an indictable only offence. So what shall happen is that both of those offences shall be tried in the Crown Court for the hearing, because of the fact that the summary offence happened in connection with the indictable only offence. The most serious offences are called indictable only offences. It is because of the fact that document in which charge is written in the Crown Court is called indictment instead of the charge. An indictment is simply a document on which offense which the defendant face are written, the document which is exclusive to the Crown Court. In magistrate court, the offense appears written simply on the summons or on the charge sheet.